For this presentation, I'll be talking about digital forensics and internal business. Since technology has become so important for businesses to run smoothly, it really raises a lot of issues in the workplace on privacy and the rights of the employees and the employers. So first, I'll be talking about the laws that govern privacy and electronic communications in the workplace. But since these laws can be interpreted in a lot of different ways, the outcomes really vary based on the cases in the courts. I'll also discuss some of the impacts of employee monitoring and the point of views of both the employees and the employers. There's a lot of different ways that employees can be monitored, so I'll discuss some of the technology as well as some of the software that has been created for businesses. So the first law that really governs privacy is the Fourth Amendment. This protects everyone against unreasonable searches and seizures by law enforcement unless they have a warrant and probable cause. So a lot of employees will use this argument against their employers and say that their Fourth Amendment rights were violated. However, the Fourth Amendment really only applies to law enforcement and government, so private businesses do have the right to search any of their property, which includes employees' computers. So employees will make this argument a lot in court, and it just doesn't hold up because it doesn't relate to businesses, only to the government. So the next law is the Electronic Communications Privacy Act, and it prohibits the interception of electronic communications, and this includes emails and phone calls. So under this act, the employers should not have the right to monitor their employees' email by either intercepting it or just even viewing it when it's already been stored, either sent or received mail. However, they use the argument that it's their property, they own the computer, they own the phone, so they have the right to view these things or listen in. Consent is an important exception to the ECPA, and when you're hired, you sign a lot of paperwork and you may unknowingly give consent for your employee to do this. So it's the employee's job to make sure that they're aware of their company's policy on monitoring or listening in on phone calls between clients. So many of the laws also vary between states. A few states ban monitoring in private places. Now, this more likely applies to video surveillance in private places such as restrooms and changing rooms rather than on a computer. Only Connecticut and Delaware actually require that employers tell their employees that they're being monitored. I think this is an important law and should be enacted in more states because employees should know that they're being watched, and you can see it has been proposed in some other states. The majority of states allow the interception of electronic communications where only one party consents to monitoring, and this goes back to signing a lot of paperwork when you're hired for a job and you're possibly giving consent without realizing. So they could read your email to someone else because you gave consent even if the other person that you're sending the email to didn't give consent. As you can see, 12 states require that both parties give consent to monitoring, and this is seen a lot when you're calling different companies and you hear the recording saying that this call may be recorded. So by staying on the line, you're actually giving your consent to this. The courts determine whether or not the employees have a reasonable expectation of privacy, but because of the different interpretations of the laws, they really vary based on the case in the court. Some courts may be more strict than others. In the majority of cases, the employer usually wins because they use the argument that it's their property. However, in this case, Stengart versus Lovingcare, the employee actually wins. In this case, Stengart was using her personal Yahoo email account to email her attorney, but she was using the laptop that was provided by her employer. She never saved the password on the computer, and she wasn't aware that there was a temporary internet file folder that was saving the websites that she visited. But she was emailing her attorney about some of the problems she was having at work with harassment and discrimination. So she ended up quitting her job at the company, and she gave back the laptop and filed a lawsuit against them. And Lovingcare hired a forensic expert to make a copy of the hard drive, and they were able to read some of the emails between her and her attorney. And it eventually reached the Supreme Court in New Jersey, and they ruled that since the email was sent on a personal password-protected account and it was between her and her lawyer, she did have a reasonable expectation of privacy. And they also held that the attorney-client privilege still took effect even though it was through email. And this is a really good precedent for a lot of employees that may be in a similar situation as Stengart. As you can see, there are a lot of different factors that influence this case, such as the fact that it was a personal account, it was a password-protected account, and it was between her and her lawyer. So since all of this varies from case to case, so do the rulings. Employee monitoring is a good thing in the eyes of the employer for a few reasons. First of all, they pay the employees to work, so they expect that the employee is actually doing work and not on Facebook all day and not being productive, because if the employee is not being productive, they may actually lose money. And monitoring also helps employees stay on task, because if they know they're being monitored, they may be more likely to be productive. It also helps safeguard other employees, because if, say, the employer can read employee emails, well, if one employee is being harassed by another employee, the employer is going to be able to see this and possibly help the situation. While employee monitoring is understandable in some instances, some employers really do take it too far and there is an invasion of privacy. I'll talk about this a little bit later when I go over some of the technology that can be used that is an invasion. And it can also lower the morale in the workplace. Like, some employers just can't focus knowing that their every move is being watched, and it may actually cause paranoia and fear. They're going to be afraid to make mistakes knowing that their employer can see everything they do, and it can actually decrease productivity because of this. And it will just overall create a bad work environment for everyone, and it's going to be really hard for some employees to work under the pressure. There are some acceptable monitoring practices. One example is access panels, which is where you can type in a code or password in order to access different facilities. So this could really allow employees to enter their company 24 hours a day if the employer allowed it, so they can get work done. There's also attendance and time monitoring. Now, this is really important. Clearly, if you're paid on an hourly wage, and you need to punch in to make sure you're paid the right amount, but it also allows employers to make sure that their workers are on time and they're not leaving early. There's also blocking websites. Now, this could be controversial depending on how much the employers block. It's understandable if they want to block Facebook and YouTube, because they want to make sure that their employees are productive throughout the day and not just on these various websites. There are some questionable monitoring practices, which include email monitoring, keystroke logging, and cell phone monitoring. Now, these things may be okay in some cases, but other cases, the employer really does take it too far. Email monitoring is controversial because it does violate the ECPA, especially software like in this picture where they actually are intercepting the email and sending it to someone else's email who's not the intended recipient. And the employee's expectation of privacy also depends on if it's a personal account or a company account, because employers provide emails for their employees, so it's easier to contact people since everyone has a pretty uniform email address. But because the companies provide the email, they argue that it's their property, similar to how they argue that it's their computer. An example of this can be seen in the case Falmouth Firefighters Union versus the town of Falmouth. And they ruled against the firefighters union because one of the firefighters was using their business email address to email sexually explicit content. So the town bought these domain names for the email addresses from Google, and therefore the firefighters had no reasonable expectation of privacy, and they should have expected that the emails could have been read. This issue can also be seen in the case Holmes versus Petrovic Development Company. This case is very similar to Stengart versus Loving Care, except that Holmes was emailing her attorney on an employer-provided email account. So as a result, the court ruled that the attorney-client privilege was not protected and that she should have known that her email could be monitored, especially since in her company policy it says that this email account can't be used for personal use. So as you can see, it really does depend if you're using your personal or company account, since Stengart was able to win a case because she was on her personal password-protected account, and Holmes, in a very similar case, lost because she was using her company account. Keystroke logging is really just an unnecessary employee monitoring practice. It records every key that's typed on the computer. It can either be a little device like this where it's plugged into the computer itself, or it could be a software program, as seen here. And you can even see this program runs in stealth mode, which means that the employee would actually have no idea that this is even happening unless the employer were to tell them explicitly that they were being keylogged. This issue can be seen in the case Brahmana versus Lembo. Lembo is the employer who was recording the keystrokes of the employee Brahmana, and Lembo did this to get Brahmana's password to his personal email account, and he then read all of Brahmana's email, and Brahmana was harassed at work as a result. And the court found that this was a violation of the ECPA and ruled in favor of the employee. Another controversy is cell phone monitoring. Employers may provide smartphones for their employees, and therefore they may use the same arguments as they did with the company provided emails and computers. It's their property, so they can do whatever they want with it. There are actually apps like Mobile Spy, that's seen here, that records all text messages and web use and email. So it's basically exactly like a keystroke logger. And also, because it's a cell phone, it has GPS tracking, so your employer could actually know where you are at all times. And this really is an extreme practice because it's unreasonable to expect employees to carry around two smartphones, one for business and one for personal use, when one smartphone is sufficient for everything. And if your employer provided your cell phone, you need to be aware of apps like this and discuss with your employer if you're allowed to use the phone for personal use. Now we'll look at some of the software that's been created to monitor employees. The first one's called Work Examiner. Now this one's a little bit more controversial, but it does do some good things and some extreme monitoring practices. It does record all the websites that the employees visit, and it even comes out with these little graphs that can show you which sites they visited and for how long. It also blocks websites, which, as I said, could be acceptable as long as you're not blocking too many websites. It even allows you to give them a certain amount of time on blocked websites, maybe if they have like a certain amount of time for personal use or they're on a break. The really controversial part is the surveillance. Now, this program takes screenshots for every certain amount of seconds that the employer can set, so you can go back and watch it like a movie and see everything that your employee has done all day. It also does email capture. I really don't think it's necessary for employers to read all email sent and received by their employee, but it can capture and save every email message sent or received through SMTP or POP3 protocols. There's also keystroke recording, which, as I said, is not necessary. Like, it even says right in there you can capture the password typed in many programs and websites. The employer doesn't need to know their employees' passwords to personal accounts. Also does IM recording, and it runs at 100% stealth, so again, the employee may have no idea that this is even going on, which really isn't fair, and the employer needs to be honest with the employee and let them know exactly how they're being monitored. All right, the next software we'll look at is by Access Data, and it's called Auditing and Monitoring. And this is a lot more appropriate than Work Examiner. This software is used more to protect the company rather than to monitor the employee. It actually is used to prevent threats, like if there's any viruses, it can detect them and help save the business. It does monitor traveling employees, but it more looks at what networks they're on to make sure that they're not on a dangerous network or anything's happening while they're traveling. It can help prevent employees from putting certain information onto removable media so that they can't give it to another company or like take information, confidential information that they shouldn't have. And it helps make sure that the employees aren't on inappropriate websites, that malicious sites that may have viruses. It's overall just to protect the company rather than to invade the privacy of employees. It's not recording their email, it's not screenshotting everything they do, and it's just an overall better program. The last program is by NestorSoft. And this one's really right in between Access Data and Work Examiner. It does monitor their internet usage and their attendance, but it really is about their productivity to see like how much work they're getting done, which I think the employer does have the right to make sure that their employee is actually doing work. But it says right down here that it's monitoring but not spying. It's a monitoring software, but it does not perform any spying. It doesn't record screens, keystrokes, or email or chat content. So I really think this is a good program that's right in between, and it will help make sure the employees are working hard, but it won't take it too far and lower the morale of the workplace. So in summary, there are acceptable and questionable employee monitoring practices, some acceptable ones being access panels, blocking websites, and attendance and time monitoring, and some questionable being email and cell phone monitoring and keystroke logging. There are laws that relate to employee monitoring, including the ECPA, but depending on the court and the case, the interpretations can vary. and employee monitoring software allows employers to monitor every move their employees make. For more information, you can visit my website. It includes everything I talked about as well as links to resources for more information.